Hi everyone, should be a short video this week. The basics between closing a sales transaction and closing a lease transaction are fairly similar in terms of how a lessee can notify the lessor, in terms of how the lessor has to provide what is set out under the lease. So tender is similar. The seller or the lessor has to deliver the goods in the agreed upon manner to the buyer or lessee. Both Article 2 and Article 2A allow for inspection of the goods by the buyer or the lessee within a reasonable period of time. We'll talk a little bit more about that in the context of our case for today. Both have a rejection provision, so if the contract doesn't say something like repair or replacement, then the default under either Article 2 or 2A in the UCC is that the buyer or the lessee can reject non-conforming goods. The accepting of the goods is similar, so you can affirmatively accept. So some sellers or lessors will actually have some sort of certification form that the buyer or the lessee must sign. You can accept by failing to reject after some period of time for inspection has passed, or as we talked about last class, you can take an action that's inconsistent with the seller or the lessor's ownership. Revocation. Remember, standards for revocation tend to be a little bit higher because the buyer lessee has been sitting on the goods. So in those cases, there must be a substantial impairment in value of the goods. And then finally, Article 2 and Article 2A both allow opportunity to cure by the seller or the lessor. As always, where things tend to get a little bit heavy is when we're talking about those finance leases, because we know, we've discussed several times, that these arrangements are a little bit strange in that the lessor, in this case the financing body, isn't actually the one providing the lessee with the goods. And so in our Raptor 7 bankruptcy case, we have a lessee, Raptor 7, who was trying to get these giant circulating watering contraptions that would water the cornfields, right, on their farm. And they were trying to get them from Ox. Raptor 7 actually fronted $25,000 as part of this transaction, but didn't have enough to pay for the entire set of used watering sprinklers. And so they had to go to Brown, who was a financer that was recommended by Ox, for an additional $80,000 to Ox, at which point Ox transferred the property to Brown, who entered into a finance lease with Raptor 7. As near as we can tell from the case, Ox did not use the $100,000 or so that he had received to actually get the goods, and these were used goods. Farm equipment is expensive. And so Raptor 7 was left with either inoperable, poorly operating, or non-existent goods, and was trying, and you see through the case, in a series of letters and phone calls and meetings and conferences, to try to push Ox, the supplier, to actually supply conforming goods, to try to sort of leverage Brown as an ally of Raptor 7 against Ox. And it ultimately didn't work. Raptor 7 never got goods that or capable of watering its cornfields in the year that the corn needed to be watered, and Rafter 7 eventually ends up going bankrupt. Now, interestingly, it does appear that under the arrangements that Brown had made, both Ox and Rafter 7 were liable against Brown. So the fact that Ox wasn't supplying the goods, it seems, did leave Ox also open to some liability to Brown. But at this point, Brown is getting in line as one of the creditors of Rafter 7 in Rafter 7's bankruptcy and saying, we should also be paid out of the bankruptcy proceedings. What practically being a finance lessee means is that the finance lessee does not have as much leeway as a normal buyer or lessee in revoking goods. It can only revoke when the finance lessee's failure to discover nonconformity before acceptance was induced by the lessors, and notably the lessors and not the suppliers' assurances. Remember, though, that a finance lessee does have claims against the supplier, like breach of warranty. What we see in this case, and of course, how strict the court is varies between the majority and the dissent, but we see that courts can be quite strict, not only when it comes to revocation, but also when it comes to rejection. Or in other words, you could frame it as courts can be quite strict about how a lessee needs to reject or accept the goods and give notice. Because in this case, we see the court interpreting really the situation against Rafter 7 in a way that deems them to have accepted faulty products, even though a different, and in some ways the dissent's more charitable towards Rafter 7 reading of the situation, you might be able to impute that notice of rejection had been given. So the big lesson as we talk about this case is when you're giving notice of rejection, make sure that you do it explicitly, that you do it promptly, and that you provide both the supplier and the finance lessor with the notice that the goods are non-conforming and that you as a lessee are rejecting them. As you're reviewing this case, I want you to try to put yourself in the shoes of the court and ask yourself, do you ultimately see the facts as more favorable to Brown, the financer, or to Rafter 7, the farm? And why do you think that is? What is it about the facts or the behavior of the parties that makes you feel as though Article 2A should be applied as against one or the other? So this is a case in bankruptcy court. Ox, the supplier of the sprinkler systems, installs them late, not fully working. Only a quarter of the sprinklers that were ordered or ever really installed. 2 systems arrive later and are pieces of junk, and depending on whether you're looking at the majority or the dissent's reading, the Rafter 7's management told the supplier at the time, these are junk, take them away. Final sprinkler system, the 4th one, never arrives, and Rafter 7 tells Brown, the finance lessor, that they're not paying because they never got conforming sprinklers from Ox. In an earlier case, Brown filed suit against both Ox and Rafter 7, got a default judgment against Ox. The case against Rafter 7 was stayed when Rafter 7 filed Chapter 12, which is special bankruptcy for family farms, bankruptcy, and Rafter 7 tried to argue it never had the right to test, and therefore inspect the sprinklers, and so Rafter 7, by extension, had never accepted the sprinklers for purposes of being liable to pay for them to Brown. Rafter 7 lost at both trial and the appeals board level, and so it had been found to owe the debt. Brown is seeking payment on this finance lease. And remember, finance leases under the UCC Article 2A, you got to pay your finance lessor come hell or high water, or in this case, come hellish heat and no water. The corn's not growing, you still have to pay the finance lessor. Now the majority frames things like this. Rafter seems to be arguing it never accepted the goods because they didn't have the opportunity to inspect them after they came non-conforming to Rafter. So Rafter never had conforming goods in the first place, never had an opportunity to see if they would work. The court says, okay, but you have to give notice within a reasonable time if you believe that the goods are non-conforming. Otherwise, as we've talked about, there is this idea that just sitting on the goods is actually a way of signaling acceptance of them. And so by letting the goods just sit there in their fields, Rafter did not effectively reject the goods. Rafter tries to bring up some cases, and this is on page 368, 369 of your book, to argue that, well, no, we have precedent that suggests that you can wait some period of time before you discover a nonconformity or give notice of it. And the court looks at the second case that Rafter brings up. This is Colonial Pacific Leasing Corp. And says, well, the rule that they're stating in there seems right to us, that a reasonable time to inspect under the UCC must allow an opportunity to put the product to its intended use, or for testing to verify its capability to perform as intended. And they say, yeah, that's right, but here 6 weeks plus, it was too long on Rafter 7's part to notify Brown that there was an issue. And the court goes on to give policy explanations for why they think speedy notice is important. And why is it important to give your supplier or your lessor or your seller notice? It's important because they're supposed to try to cure. Right? So if you don't put them on notice, how can they try to cure? Moreover, right, it gives them an opportunity, perhaps the seller, finance lessor, supplier, gives them an opportunity to help mitigate the losses, right, of the buyer or the lessee, losses that they may ultimately be liable for. But there is this sense that they should have an opportunity to try to cure and an opportunity to try to stem the damages that they will ultimately have to pay. Rafter contends that the bankruptcy court's finding that it failed to seasonably reject the goods was an abuse of discretion because the other side, Brown, hadn't raised that failure at trial. But this federal court reviewing the case says, no, this is within the general issues and principles articulated by the parties. And so in that case, the fact that in the bankruptcy court's mind and now in the federal court, 10th Circuit, I believe, but I'll double check on that. The 10th Circuit's mind, that the time period here for acceptance or rejection, the window had passed, right? And that it must be done within a reasonable time with notice to the lessor. So ultimately, Rafter 7's attempts to bring in Brown to help it against Ox, the court says was too little too late. The dissent looks a little bit more into the background of the transaction. It notes that Rafter 7 had given Ox a number of down payments. That's when Ox hooked Rafter 7 up with Brown. Rather than focusing on acceptance or rejection, the court in the dissent focuses more on this notion of delivery. Were the goods ever truly delivered? And that element they felt like was not met in this case because the sprinklers were not delivered in good working condition. They look at a November 1st letter that Rafter 7 wrote to Brown, and they say, we think that that's enough to be viewed as a seasonable rejection of Ox's ineffective delivery. It doesn't make sense, the court seems to say, that Rafter could reject goods from this, they say seller, the supplier here, Ox, and yet accept them from Brown, the finance lessor, at the same time. And when they talk about these policy notions of, well, it makes sense to give the supplier notice so that they can cure or that they can mitigate the losses, perhaps by coming and taking refrigerated goods that had a short shelf life and taking them away to where they could sell them elsewhere. Do those kinds of policy justifications make sense? Well, no, says the dissent, because Ox was on notice that it either wasn't supplying the goods or hadn't supplied conforming working goods, and it wasn't as though these sprinkler systems were perishable. What I think we see through this discussion, and it is quite lengthy, it's probably the longest case you have to read in the entire book, it really nicely, I think, shows you how the fact that so much of the UCC analysis ultimately boils down to is the commercial behavior of the parties reasonable under the circumstances? And how does a court view the reasonableness of their behavior? Right? Is so critical, because this is essentially one side of the court, the majority, saying the notice wasn't adequate enough. You needed to do more earlier on and in a more obvious manner to alert Brown in particular that Ox wasn't performing, versus the dissent that I think ultimately part of what they are thinking about is Rafter 7 was trying really hard to work with Ox, probably because they already had $25,000 in the hole, and they wanted to try to do what they could to goad Ox into behaving appropriately under the contract. And because they spent so long spinning their wheels doing that, ultimately Rafter 7 loses out in this case. Now let's move on and we will talk about problem 19.1 in our in-class discussion. So let's move on and talk about the Convention for the International Sale of Goods for a bit. The convention really tries to keep things clean in terms of breach. And so they say that a buyer, now we're back into talking about sale, although of course international, so two parties that are in treaty countries. A buyer can only avoid a contract when there's been a fundamental breach by the seller. So a substantial deprivation of the aggrieved parties' benefit of the bargain, or seller's failure to deliver. All right, and depending on how long that failure to deliver takes place, it amounts to much the same thing, right? Because if you don't have the goods, you can't use the goods. Right? So that's 100% deprivation of your expected benefit. If the seller does deliver and the breach is not fundamental, the buyer must keep the goods. Right? Seller has an opportunity to cure. Buyer can sue for damages or ask for a cure by the seller. Right. The convention does not have provisions for the buyer holding on to the goods for the seller to come and arrange to take the goods back. That's just not practical when we're talking about international sales. It would be too cumbersome for the seller to get them back. So once again, the seller does deliver. The breach is not fundamental. Buyer keeps the goods and the seller has an opportunity to cure. That's CISG Article 48. The buyer can also affirmatively ask the seller to cure. That's Article 47. Or the buyer can sue for damages, and those are Articles 74 through 77. So looking at this air conditioning case, we have Delci, which is an Italian air conditioning manufacturer, and Rotorex, which is an American company that makes air compressors. And Rotorex overpromised, underdelivered on the product. The shipment that they sent that was supposed to go into a line of air conditioners by Delci called Ariel, the air compressor did not conform to the sample unit that Rotorex had provided and did not meet the technical specifications that Rotorex had said the air compressors would meet. Rotorex refused to supply conforming air compressors, claiming that the performance specs were, quote, inadvertently communicated, unquote, to Delci. It's on page 377. So remember, one of the things that you can ask for as a buyer under the convention is for the seller to cure. That seems to be what Delci did here. They informed Rotorex that the air compressors were not working according to the specs, and after several unsuccessful attempts to cure the defects, Delci asked Rotorex to supply new compressors, and Rotorex refused. And so the buyer did attempt here to get cure from the seller. The court seems to think that this is a fairly straightforward case. The trial court ruled for Delci to the tune of $1.8 million in damages. The court never really gets to Rotorex's defense here. Delci says there's a breach of contract. We should get damages for our ultimate inability to get substitute compressors in a timely fashion. So ultimately what they're seeking are the lost profits from the air conditioners that they would have sold had the Ariel line been able to successfully go forward that year. And the court has to decide, was this a fundamental breach? And they look at Article 25 of the convention that says, a breach of contract committed by one of the parties is fundamental if it results in such detriment to the other party as substantially deprive him of what he was entitled to inspect under the contract, unless the party in breach did not foresee, and a reasonable person in the same kind of circumstances would not have foreseen such a result. And you can see here why it's probably a pretty easy argument to make on Delchi's part to say, we were ordering air compressors for this particular air conditioner. If we don't get the parts, we're not going to be able to make the air conditioner. We won't be able to sell it. And so the foreseeability here is straightforward. Any reasonable person could foresee that shipping non-conforming goods to a buyer would result in the buyer not receiving that which he expected and was entitled to receive, because the air compressor were important in determinants of the product's value. The district court's conclusion that this was a fundamental breach was popular. Right? Rotarex could reasonably foresee the result of their breach, right? The business losses by Delchi. And we're going to go through talking more about the convention in problem 19.2. Have a lovely evening, and I'll talk to you on Tuesday night.